Good afternoon. The Memphis and Shelby County Board of Adjustment is hereby called to order for its regularly scheduled meeting of April 29th, 2026. My name is Tim Rainey. I'm chairman of the board. Mr. Jeffrey Penzis serves as secretary of the board. Mr. Penzis, may I get a roll call, please?
Mr. Bruce.
Present.
Mr. Claybrook.
Here.
Ms. Skurlock.
Here.
Mr. Love.
Here.
Vice Chair Savage Sheldon.
Present.
And Chair Rainey.
Here.
We have a quorum.
All right, thank you. The Memphis and Shelby County Board of Adjustment is the oldest appointed governmental body in Memphis and Shelby County. We were established in 1925. The board hears appeals from the administration of the zoning ordinance, requests for variances from the zoning ordinance, and other requests as articulated by local zoning laws adopted pursuant to the enabling legislation. The 8 members of the board are appointed, 4 by the mayor of Memphis and 4 by the mayor of Shelby County, with confirmation by the Memphis City Council or Shelby County Board of Commissioners. We serve without remuneration. At this time, I would like to swear in the staff. You may remain seated. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. If the record will show that Mr. Campbell has joined the board. Mr. Secretary, may I get a motion to approve the minutes from last month's meeting?
So moved.
All right, are there any discussion of the minutes? All right, all those in favor signify by saying aye.
Aye.
Any opposed? That motion passes. Mr. Secretary, if you'll provide us the secretary's report, if there is one this month, and then explain the procedure for today's meeting.
Yes, sir, Mr. Chairman. As for the Secretary's report, there are no announcements this afternoon. The procedure for this meeting will be as follows. I will introduce each case as listed on the agenda. Copies of the agenda can be found on the front podium. For each case, the planner with the Division of Planning and Development will give a presentation. At the conclusion of the staff presentation, the applicant will have 5 minutes to present his or her case. After the applicant's presentation, those speakers in support will have a total of 5 minutes, then those speakers in opposition will have a total of 10 minutes, and finally the applicant will have 2 minutes to provide rebuttal. These times do not include time for questions from and answers to members of the board. The chair may also provide additional time, provided both sides are given an equal amount of additional time. All parties who wish to provide testimony to the board will be sworn in by the chairman. If a member of the audience wishes to provide testimony in support of or in opposition to a particular case on today's agenda, he or she will need to fill out a speaker's card for the record. Speaker's cards are available at the front podium. Once filled out, speaker's cards can be submitted to any DPD staff member at the left podium. We do not need speaker's cards from the applicants since their names are already part of the record. After all parties have been heard, the board will close the public hearing, make a motion, and then deliberate on the case. If the applicant or any speaker would like to be heard after the conclusion of the public hearing, or if a board member wishes to hear additional testimony from any party, a 2/3 vote is required to reopen the public hearing pursuant to the board's rules of procedure. Please note that once the public hearing is reopened, both the applicant and opposition will be allowed to provide additional testimony and/or rebuttal. All motions by this board will be made in the affirmative. The private act governing the board requires the affirmative vote of at least 5 members to approve an application regardless of the number of board members present. The board may also vote to hold an application for a period not to exceed 3 months with the consent of the applicant or 1 month without the consent of the applicant. All section numbers that we refer to come from the Memphis and Shelby Unified Development Code, or the UDC, which was adopted by the Memphis City Council and Shelby County Board of Commissioners in August of 2010 and became effective on January 1st, 2011. I will introduce the entire UDC and make it part of today's record, thus dispensing with the reading of individual sections. The board is vested with the power to act on these cases before us today under the provisions of Chapter 9.22 of the UDC. Mr. Chairman, I submit that all cases have been filed in proper order, all applicants have been notified of this hearing, and all notice requirements have been fulfilled as required by the UDC.
Thank you, Mr. Secretary. At this point, the board will establish a consent agenda. To establish the consent agenda, the Secretary will call out each eligible case. If any member of the audience, staff, or board member objects to a case being placed on the consent agenda, he or she should do so by a show of hands when the Secretary reads that case. Once the consent agenda is established, the board will vote on all cases placed on the consent agenda as a whole and will not hold individual public hearings on those cases. Mr. Secretary, which items on our agenda today are eligible to be placed on consent?
First, I would just like to note that item number 2 has been withdrawn. Item number 3, BOA 2025-104, Thomas Street as a hold for 1 month. Item number 6, BOA 2025-148 at 5380 Benjistown Road as a hold for 1 month. Item number 7, BOA 2025-149 at 5350 Benjistown Road as a hold for 1 month. Item number 8, BOA 2026-16 at 4590 New Allen Road as approval with conditions. Item number 10, BOA 2026-24 at 4449 Knight Arnold Road as approval with conditions. Item number 11, BOA 2026-26 at 5270 Poplar Avenue as approval with conditions. And item number 12, BOA 2026-27 at 6750 Poplar Avenue as approval with conditions.
All right, thank you. If we could get a motion to approve the consent agenda as established by the secretary, that would be agenda items 3, 6, and 7 as holds, and then 8, 10, 11, and 12 as approval with conditions.
So moved.
Second.
All right, I want to remind the board that by voting on the consent agenda, he or she affirms that he has read the staff report and is in full agreement with the conditions. Mr. Secretary, may I get a roll call, please?
Mr. Bruce,
Yes.
Mr. Campbell,
Yes.
Mr. Claybrook,
Yes.
Ms. Conrad,
Yes.
Mr. Love,
Yes.
Ms. Scurlock,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
All right, if you're here for 3, 6, and 7, you've been held as requested, but if you're here for 8, 10, 11, or 12, you've been approved as requested with the conditions of the staff. Mr. Secretary, will you call the first case we're going to hear this morning, or this afternoon, I'm sorry?
Item number 1, BOA 2025-127 at 3141 Ferris View Road.
Okay, I see the applicant. Is there any opposition here for this case? Supports, okay. All right, if we could get then a staff report, and then we'll move to our applicant.
Good afternoon. I'm Chloe Christian, presenting this case BOA 2025-0127. The applicant, Brian Yoakum, is here with us today, and the property is located at 3141 Ferris View Road. And this is a correspondence case to case number BOA 2023-0166 to remove a condition from the original case approval. Here's a location map of the property on the left-hand side, and a brief background and introduction of this case. So for starters, per the UDC, only one billboard is permitted on an individual lot, and no other principal or accessory uses are allowed on said lot. So the subject property contains a transportation services building with accessory EV charging, which was approved with this correspondence BOA case, and a non-conforming off-premise sign that was constructed in 1986, which also received a variance for a setback encroachment. So one of the conditions of approval of that 2023 variance, which allowed for the EV charging, was that the non-conforming sign would be required to be removed within 12 months, and that did not happen. So in September of 2025, a citation was issued for the failure to remove said billboard. And in November of last year, this case was filed to relieve that condition. Here's a zoning map of the property. It's zone heavy industrial. As you can see, there are 2 BOA case overlays on top of that, which, excuse me, were for the setback encroachment of that sign, which was built in 1986, and the other variance was for the EV charging. Its land use is industrial. It's currently a transportation company. Here's some photos of the site and the billboard. These are photos from the enforcement case. This is just a survey of the property. As you can see, there's an existing industrial building on the site, and up in the top corner there is where the sign is located. Here's a zoomed in version of the property. The orange highlighted portion shows the location of the sign and the installed EV charging units. Just for another refresher or overview of the timeline for this case, so in 1966 was when the industrial principal structure was built on the property. In 86, the off-premise sign was erected, and there was a variance that was approved to allow it to encroach into the front setback. However, at this time, off-premise signs were allowed to be constructed on a lot that already had a principal structure, so there was no issue at that point in time. However, when they applied for a variance to allow the private use EV charging, that billboard is now considered non-conforming. So that's why that condition was placed. As I mentioned before, the billboard wasn't removed, and so the citation was issued. And following that, this case was filed. There were a few holds on this case. So in December, the first hold was issued, and the applicant submitted a letter that is included in your staff report. In January, the meeting didn't occur because of the inclement weather. In February and March, the case was held as well. And there is an updated letter that was received in March from the applicant that is also included in your staff report. And we did receive a copy of the lease of the billboard from the applicant, which has the lease set to expire on May 1st of this year. Just to be included in here are the notices of disposition for the previous BOA cases. This one on the right is for the EV charging, and the one on the left is the 86 case, which was a variance to allow that sign to encroach into the front yard setback. Another thing that we wanted to point out, there were some questions about the differentiation between EV charging stations and EV charging units. So while it does state in the staff report from 2024 that the variance is to allow EV charging stations, there is a distinction between stations and units. What's actually been installed here would be considered EV charging units, as they are private and not for public use. However, it's clear that in our interpretation in the staff report, we understood that the EV charging units were private use. This is allowed as an accessory use in the industrial district. However, since the site is non-conforming, it did require a variance to permit said accessory use. This is just some snips from the code that show the different definitions of EV charging units versus EV charging stations. As I mentioned, the EV charging unit is just referring to the actual infrastructure unit to which electric or hybrid electric vehicles are connected for the purposes of charging the vehicles, whereas a station is an actual facility that provides EV charging for a fee. So what has been installed here are EV charging units. However, regardless of if it was a unit or a station, a variance would have been required due to the fact that the site is non-conforming. As I mentioned before, the sign was built in 1986 and is considered legal non-conforming per UDC subsection 10.2.3. And part of the reason that is considered non-conforming would mean that any construction on the site would trigger an increase in the degree of non-conformity of the sign. And so I just have here a aerial snip from 2017 versus 2025, and you can see in that rectangle portion, there was some site improvements that were performed in order to install said EV charging, which again increases the degree of nonconformity and is why that 2023 variance was needed. This is just a elevation that was included in the BOA application and the subsequent electrical permit that was pulled for that EV charging to just further prove that improvements were done on the site and that the degree of nonconformity was increased. And the intent is that if the off-premise sign were to remain, the intent of the UDC would be in violation. It's pretty clear that if any construction is done on a site that is legal nonconforming, it would need to be brought up to code, essentially. And so, as we stated in the 2023 staff report, there is not really a hardship or practical difficulty that's been presented to justify granting the request to remove the condition. And since the lease is set to expire May 1st, we proposed a condition that would just match the removal of the billboard with that date. So we recommend approval of the correspondence to revise that condition to say that the off-premise sign must be removed at the end or upon the termination of its current lease on May 1st, 2026, and the original conditions of approval from the previous BOA case would remain. And that concludes my presentation, but I'm happy to answer any questions. Thank you.
Okay, thank you, Ms. Christian. Are there any questions for staff? Okay, Mr. Yoakum? And as you're coming up, we have kind of a weird thing in our rules to where like the applicant gets 5 minutes and support gets 5 minutes. But I'm gonna let you know when the 5 minutes are up and we'll let the support then probably defer to you if you're still going, is what I would think, but I'm just letting you know.
Yeah, thank you, Chair. I will endeavor to be brief as best I can.
I wouldn't do it, but you know, it's just kind of weird that you don't get as much time as you'd like if there's support there. So I think a lot of times the support will say, no, you keep talking.
Well, well, thank you. And I'm not, we also have Mr. Brittenham here on behalf of the tenant. So I want to make sure that I'm respectful of his time. But as a preliminary matter, before I introduce myself, I've presented some additional documents today that I'd like to ensure are going to be included in the record. That would be position paper that was submitted by my law firm in support of this application on April 24th. So I've submitted that and would like that included in the record. I have some email correspondence with County Attorney, my good friend, County Attorney Mr. Rolling on this case. We'd like those email correspondence included in the record as well, please. And finally, I've got a copy of the PowerPoint presentation that we're going to work through briefly and expeditiously here today. We'd also like to move to have that included in the record, please.
Perfect.
Okay. My name is Brian Yoakum, 3565 Walnut Grove. I am an attorney with the law firm of Evans Petrie. I represent the Robert Anthony Armstrong Marital Trust, and that is the trust that owns this real property at 3141 Ferris View. And I have here today with me Mr. Leo Lazarus. Leo is the Chief Operating Officer of Armstrong Transportation and is available for any questions you may have of him. Is my clicker not working? Okay. So Armstrong asks this board respectfully today to do one straightforward thing. We're asking to delete condition 1 from BOA 2023-166 as Ms. Christian referenced. The condition requiring removal of a billboard that has stood lawfully on the property since 1986. In the alternative, we ask that this board void 2023-166 in its entirety, because that variance was granted, it was completely unnecessary under the UDC, and it was predicated on a mistake not by the property owner, and we'll describe that in greater detail. And that includes the conflation of private electrical vehicle charging units and electric charging stations which were addressed by Ms. Christian. Our position is that no variance was ever required, and because no variance was ever required, the entire predicate for this condition 1 collapses and should be removed. Next slide. Ms. Christian had a very nice timeline, so I won't harp too long on ours. I think they align in substance. But this property sits on a logistics corridor near I-240 in Lamar. It's zoned heavy industrial, and the property's been operated since the 60s, as discussed. There's a 45,000 square foot building on the property, and this off-premise advertising sign that we're discussing here was erected in 1986. And at that time, the applicable zoning for that property was light industrial, and off-premises signs were permitted as accessory structures. The building permit was obtained, which is important under the statute. The building permit was obtained, and this billboard was granted the setback relief, as Ms. Christian referenced. Next slide. And this billboard has been in continuous uninterrupted operation for nearly 40 years. It hasn't been expanded, it hadn't been altered, it hadn't been intensified. There's been no complaints about this billboard in the record. It's at Lamar and I-240. It's been an exemplary performing billboard over the years. And I think staff even recognized today, it's a legal non-conforming use under UDC 10.2.3. The Lamar companies hold a long-term leasehold interest that's been recorded. I will take deference at this point. The lease does not expire May 1st. That's incorrect. So, and even if it were correct, I don't think the timing of the lease applies to your legal analysis here. But that lease does not expire, and Mr. Britton will discuss that further. Next slide, please. So what happened here is this transportation company decided that it was going to modernize its fleet of vehicles, and it was sold a fleet of vehicles by a Swedish company called Einride. Einride was tasked with getting the electric charging units established and installed. Einride hired an out-of-state land use firm called SSC, who applied for this last variance. It turns out the variance wasn't required. I don't know why SSC even applied for this variance. Nobody for SSC appeared at the hearing. There was no opposition at the hearing. I've reviewed the video. It was accepted immediately without opposition and approved. Importantly, my client Armstrong was never made aware of this condition to remove the billboard. They never knew about it. They didn't find out about that condition to remove the billboard until they heard that there was some sort of citation, some sort of case happening in environmental court, which is when they engaged us and we've proceeded. It was a mistake by SSC, out-of-state land use planning firm, to even apply for the permit. And what was installed, I believe, has been acceded to are electric charging units, so that will help us move more quickly. This is the comparison between charging units and charging stations. I still believe in the initial staff report there was clear confusion between charging units and charging stations, but this is a private use. It's behind a locked fence. It's for nobody. You and I can't go plug our cars into it. It's only for their trucks. And then, importantly, an electric charging unit is a permitted accessory use in this industrial heavy property, as it is in every other type of property under the UDC, under my understanding. So that was what was installed, and it is our position that the only thing required to install these electric charging units was the commercial electrical permit, which was obtained on April 24th, 2024. So they've got that, and it's in the staff record. It's in the staff report. So next, please. So the definitional distinction is important. The UDC draws this clear operative distinction between the two categories. The charging unit is the actual infrastructure unit to which vehicles are connected for recharging and the code expressly authorizes they be installed as standalone accessory uses in any zoning district. All right, next slide. Because the electric vehicle charging units are permitted accessory equipment in any zoning district and specifically listed as a permitted accessory use in industrial heavy, no variance was required to install them. Armstrong only needed the electrical permit, which they obtained, and the entire premise of the prior variance request was a mistake. As the variance was unnecessary, then the conditions attached to it, including the condition 1, have no lawful foundation. Next slide, please. The EV units did not, it is our position that they do not increase the degree of nonconformity at this site. The degree of nonconformity is measured by the characteristics that render the use nonconforming. Here, the billboard's nonconformity arises solely from the fact that the current UDC classifies off-premise signs as a principal use requiring a separate legal lot. That classification in the billboard's lot status are what makes it nonconforming. Armstrong's installation of a permitted accessory equipment for its lawful principal use did not alter the billboard's setback. It did not change the billboard's height. It did not change its dimensions, locations, its signage areas, its intensity. The degree of nonconformity is precisely the same today as it was before the EV charging unit was installed. And it's our position, as this slide shows, that the wrong regulatory framework is being applied here. Staff is pursuing UDC 4.9.8A4, which provides that a permanent off-premise sign does not share its lot with any other principal use or any accessory use serving a principal use on an adjacent lot. That's an erection standard. It tells you when a new off-premises sign may be built. What it does not tell you is that a 40-year-old lawful non-conforming sign must be removed because the property owner added a permitted accessory equipment for a completely unrelated use. So it's our position that reliance on that UDC section is misplaced. Not only is it misplaced, using that section as a retroactive removal tool produces a sort of a preposterous result.
Hey, we only have like a minute left.
Okay, I'll move quick.
Like of the 10 minutes.
Okay, to follow the staff's analysis would mean that any property in Memphis and Shelby County with a legal non-conforming billboard could never add any permitted accessory equipment, no matter how unrelated to the billboard. We also have arguments related to the statutory analysis in Tennessee. It is our position, and it is well laid out in your brief that you've received from us. We believe that 13-7-208B2 applies here and is directly applicable to this situation where you have a non-conforming use permitted to continue in an off-premise sign, and the sign's presence does not preclude any new or additional conforming use. We think that's squarely on point, the state law. I believe that the attorney for the board believes that it's been preempted by Section 210. We've briefed that argument, but honestly, we don't even think you need to get to that argument because the UDC mitigates in favor of maintaining this billboard. So I'll end at that. Thank you for your consideration. We're glad to answer any questions you may have.
Okay, are there any questions for Mr. Yoakum? Yeah, we have a few questions.
Yes, Mr. Yoakum. You mentioned that the lease date for the billboard was not correct. What is the correct date?
There's not a set termination. It's open to ongoing extensions, and counsel for our tenant here is to discuss that issue.
Okay.
Okay, other questions? All right, Mr. Brittenham, if it's okay with the board, I'd like to give him can you do 3 minutes?
Companies. Before my time starts, I'd like to pass out some documents, please. First of all, I have 2 documents for the official record. Then I have a summary and a brief for the board members.
Okay.
And if we could take a moment to get those out to the members, please, sir.
All right, go ahead.
The last 2 members, did they get 2 copies, each copy?
Did y'all each get? Here's an extra set, because I have the record copy as well.
Okay.
The one, so I'll hold on that and make sure it gets
Okay,
to-
great.
Yep.
Thank you. Do you have the summary?
And Mr. Chairman, just so you know, we're sharing.
Yeah. We'll make sure that everybody can look at one.
Okay, thank you.
Yeah.
All right, I'll go ahead and start. Lamar Companies is the tenant of Armstrong. Lamar owns the billboard. And there are 3 issues in this case. Number 1 is whether Lamar, as a lessee property owner, was required to receive notice of public hearing for case for the BOA 2023-0166 case. The answer is yes. However, Lamar did not receive notice of the hearing, and notice is required under the UDC for a tenant on this particular site. Notice, there's no notice anywhere in the record to Lamar. Lamar had no idea that this condition number 1, or even the case, was being brought in 2023. So, therefore, Lamar did not receive notice of this hearing. Without notice, Lamar had no knowledge of the hearing. was not appraised of condition number 1 affecting its property rights, and did not appear. Therefore, condition number 1 is invalid. And in the brief, you'll find case law supporting that position. Number 2, whether the original application request should have generated an electrical permit to install EV units. The answer is yes. Board of Adjustment case 2023 applicant request should have been reviewed by the building official as application for an electrical permit, because this was a request to install EV charging units. And according to the Memphis City Charter, the Memphis City ordinances, the UDC, only the building official is charged with the authority to issue electrical permits. The zoning division, the section of the Division of Planning Development, is not authorized to make a decision on electrical permits or building permits. Only the building official has that authority. The building official, according to the record, did not have any input in making the decision when this application was filed, whether it should be a variance request or whether it should be simply a submission to request an electrical permit, which is a pretty simple process. And if you look on the second page of the summary, UDC section 1.7.c, on conflicting provisions, the development code does not interfere or supersede the building code. And the building code is what should have been used in making the decision in the beginning in 2023. That didn't happen. And finally, UDC section 9.20.1, the zoning administrator and the building official are authorized to interpret the UDC. The building official, there's nothing in the record. And number 3, whether the Board of Adjustment action setting, confirming, modifying condition number 1 constitutes an exaction. That is a government taking without compensation to Lamar. The answer to that is yes. So the taking is putting in condition number 1, saying that the billboard has to come down in exchange for the variance so you can put in EV charging units. And that's an exaction. That's a government taking without compensation. And to just boil it down, this would be like Armstrong wanting to put in a heavy-duty washer and dryer units to do the laundry of the staff that works for Armstrong on site. And in order to do that, staff would say, you've got to go to the Board of Adjustment and get a variance instead of just getting an electrical permit from the building official. That's all that was required in this case. So with that, we support, we adopt and support the Armstrong position and respectfully request that you delete condition number 1, or in the alternative, void the variance that was granted in case number 2023. Thank you.
Okay. Thank you, Mr. Britton. Are there any questions? We got a question, sir. Real quick, questions?
Yes, sir.
That billboard, the billboard is shaped like a V up there. The billboard there on the property is shaped like a V. And currently they have advertisements on one side and not on the other. What is your reason? What understanding does the owner have of the reason of why they're not putting signage on the other side?
Well, in billboard lore and in the industry, there's a term called intended to be viewed. Intended to be viewed.
Okay.
Seen, viewed. So the reason it's situated like that is because it's intended to be viewed from the freeway, from the Interstate 240.
I'm not asking about the configuration. I'm asking why you haven't made money of people putting signage on that, of the side that doesn't have any signage on it?
There's ads on both sides.
Mr. Armstrong says there are ads on both sides of the billboard. I'm sorry, Mr. Lazarus. Mr. Lazarus says there are signs on both sides of the billboard. So it is intended to be viewed from the east and from the west.
Right, didn't we have a case where they were supposed to not use the other side?
We did have one of those one time,
Right, that's what I'm
not
getting.
here.
Okay, it's not this.
That was at Poplar, and they put up that weird little screen where you can only see half the billboard at once. along the
Okay, I
interstate.
thought it was this one at
I think
Fair,
that
we had another
that's
one
not
at
a problem with
Ferrisville. Okay,
Yeah.
okay. Well, then disregard my question.
Are there any other questions before we? All right, we'll have time for rebuttal as well.
Okay. Thank you very
Okay.
much.
All right, thank you.
Appreciate your support for approval of item number 1. Thank you.
Okay, so we're going to move to opposition, and I believe we might have a statement from the city attorney on that. Ms. Hale?
Julia Hale, County Attorney's Office. Very briefly, it is correct that the Private Act does not address accessory uses, but our private acts enabling zoning here do explicitly prohibit expanding a non-conforming use. Overall, it is up to the board to decide whether adding the accessory use was an expansion of this non-conformity, whether that accessory use is allowed, whether the previous variance should be modified, whether the notice was proper in previous variances, and whether the condition should be deleted or not. And then finally, we would argue that, or we wouldn't argue, the board can decide if they lawfully determine that the board lawfully relied on the previous applicant's duty to notify the tenant regarding the previous application. And do you have any questions?
Let's see. So my understanding, and this may not be a question for you, Ms. Hill, my understanding is typically when anything is done at a property that's had a billboard or another use is going to be used, just because you're not changing that primary use of the billboard, that's considered expanding the use of the property and expanding the non-conformity of the property. Is that how staff use that? Am I saying that correctly?
Yes, the Division of Plan and Development agrees.
Yeah, so even though we're not touching the billboard, we're adding uses to the property, and multiple uses is the non-conformity.
Yes.
Okay, just want to make sure I understood that from the past. And then, has the staff ever sought out to pull, like when we do our, we'll come back to yeah, don't worry. When we're looking at applications, do y'all feel that you're required to check title to see who owns the property, or to see if someone has filed a lease or anything like that, and then give them notice, or do we just give notice typically to like more fee-related landowners?
Our public notice is done using the assessor's parcel data.
Right, and that's what we use. And is that what the code just says? That's how we find? Is that process in there?
The code says we have to notify property owners.
Property owners, okay. Are there any other questions? Because I don't think we have anyone else here necessarily in opposition to this case, correct? Okay. Are there any questions before we go back to rebuttal? All right, seeing none.
I have questions. I'll have some questions for the board.
Okay, okay. So we're in rebuttal. Mr. Britton, were you wanting to come back up? Two minutes.
Well, I want to make sure I understand what staff is saying about the nonconformity. It's the billboard that's nonconforming, not the trucking operation. The trucking operation is independent of the billboard. And the trucking operation, the EV charging units are specifically allowed as an accessory use in IH zoning. And that's what this is. That's what you go to first. If you follow the comment of staff, I go back to my example. If you put in a heavy-duty washing machine and dryer, staff is going to tell you, you've got to go to the Board of Adjustment because now you're non-conforming. The site is non-conforming. Any activity associated with trucking that is added to the site, staff is saying, you've got to go to the Board of Adjustment. And here's the problem. DPD staff or the zoning staff has the opportunity to consult with the building official and under the building code, make a determination about whether it's a building permit issue or if it's a zoning issue. If it's a building permit issue, that takes precedent over the UDC. The UDC cannot conflict with the building code, and that's in the UDC. So that's been adopted by the city council saying the building code is primary to the UDC. If the building official had reviewed this application in the beginning, the building official would have issued an electrical permit to install the sockets, the units on the property because it's for private use and it's allowed as an accessory use. So all you need is an electrical permit. Instead, we've gone through all that different time to now. And I believe Mr. Yoakum wants to add one comment.
Okay.
Thank you. I'll be very brief. I just wanted to take the opportunity to address that argument and respectfully suggest the board review the Tennessee Court of Appeals decision in BMC Enterprises versus City of Mount Juliet, 273 Southwest 3rd, 691, Tennessee Court of Appeals decision, where similarly the Board of Zoning Appeals in that case focused in that court's opinion on the wrong question. And the question here, based on that opinion, should be whether the nonconforming use itself has expanded. And in our situation, of course, the nonconforming use of the billboard has not expanded. It's not intensified and it's not changed. And we believe that that BMC Enterprises case would be dispositive on that position.
Okay.
Thank you.
Don't go anywhere. We may have questions. So just so you know, a couple questions. So is it not typically DPD's, what I remember, and I could be wrong on any of this, that when you have a billboard on a site, it becomes the primary use of the site? Does that make sense?
It's one of the principal uses.
Or principal use, thank you
Yeah.
for that. And then had they wanted to do something inside the building that required an electrical permit, that wouldn't necessarily have triggered anything. The fact that they improved things on the site, you know, visible is why we're in zoning world, not just building permit world.
We would agree with that. I don't think we've ever went in after anyone for installing a washing machine.
Okay. Are there other questions for the applicant or for staff? I do have some questions for, I think this would be for Mr. Yoakum. So I have a copy of, it looks like the application was partially, it was signed possibly by a trustee with Cumberland Trust, and the property's owned by the Maryville Trust or something like that. I may have the names wrong. Was that not the owner of the property that signed the application? Like, it wasn't Infield that signed it. It was someone that said they're a trustee of something.
Yes, I do understand that Cumberland Trust was a previous trustee of the trust, and they're no longer the trustee of the trust, and we have attempted to get information from them, but their signature on there would indicate that they had this put in front of them and certainly would have signed it. My primary point, is that they were never advised of the hearing. They didn't know the hearing was happening. Einride didn't tell them. SSC didn't tell them. Nobody had any understanding that there was going to be a potential condition that would require removal of this billboard that's under a long-term lease.
Okay. So do you, and just, I don't know if it really matters at this point, but do you think they were possibly a trustee then, or they were a trustee at some point well before the application and just, hey, here's a trust thing, we need this signed?
I believe Cumberland Trust probably was the trustee at the time that it was signed.
Just curious. Okay.
Yes.
Other questions? All right, thank y'all. All right, making it easy. Are there any questions for staff before we go to our discussion?
I have one, Mr. Chairman.
Yes, sir.
So just in regards to the nonconformity and when that took place, what initiated the nonconformity of the billboard?
When the legislative body added to the UDC that a billboard cannot share its lot with any other principal use or an accessory use serving a principal use on an adjacent lot.
One use, one parcel.
Yes.
And the trucking business came in after the billboard. And I know some of this is in the report, but
I think it was before. It's been there since the 60s.
the business.
Yes, I believe it was there since
Okay.
well, at least an industrial building was there since 1966.
Yeah,
And then the billboard.
in 86.
Okay.
I think that was the variance they got only was because of the closeness to the street, not because of the use of it. It was allowed by right in 86, but then zoning changed with the UDC. Yes, ma'am. You? Savage Self.
Quick question. We're mentioning the removal of and I don't know if I was, but the other conditions that were on that variance, do we know what those are? I know we're asking for one to be removed, but do we remember what the other conditions for the variance previously was?
The conditions for the EV charging, they're on the screen. So 2 and 3 are from the original 2023 case, and then the original condition 1 read that the billboard must be removed within 12 months.
Gotcha. Thank you.
Let me ask the staff for, well, make sure I understand this. So the applicant is arguing that if they had never filed the application a couple of years ago, then we wouldn't be here today. There would be no question about the sign. And they say they should not have been required to file it because they were installing EV units. I just wanted to hear the staff's view on that. I mean, would they have been required to file, to submit an application anyway? Or what do you, I just want to hear your side of that argument.
So we disagree with that, essentially because the site was non-conforming, then the non-conforming rules apply. And this did involve, obviously, new construction when they put in the electrical EV charging units. And essentially, it's section 10.2.3 of the UDC, which regulates non-conforming uses. And it's even including but not limited to, and there's an A, B, C, and D, which lists several things you cannot do.
Thank you.
Other questions? All right, so if we could get a motion to approve BOA 2025-127 as conditioned by staff, then we can discuss it. Second. We need a movement.
So moved.
We got to move.
So moved.
Second. All right, moved and seconded. Okay. Any discussion? those leases are often written where you can continue to renew them if you like. So they could, I'm sure it has renewal language in it.
But the must be removed is pretty definitive.
Yes.
Does not lead you to believe that it could be
Oh.
renegotiated.
Can you
Well, I
speak
mean-
into the microphone, please? Sorry.
The must be removed language does not
Yeah.
indicate that it can be renegotiated.
Well, I would say that it doesn't matter. Like, we're just saying if they want to do this, they got to get rid of the billboard, buy it out, do whatever they want to, get right with whoever their tenant is. So whether or not it can be renegotiated doesn't necessarily have to come into what we're even thinking about it. We often think about that because we're trying to find a good path forward, but us granting a variance and saying a billboard must be removed, they could have a 99-year lease and we still could put that condition on it. And that's for them to figure out if they want the variance. They might say it's not worth it.
Okay.
Yes, ma'am.
I guess I'm still trying to grapple with non-conforming, and then the notion that no variance was required. So I guess I'm trying to confirm or grapple with non-conforming came from legislative.
Well, I think the argument being made by the applicant is that the billboard's what's non-conforming, and we didn't change the billboard.
Okay.
I think the argument made by staff is it's not the billboard. The billboard makes the site non-conforming by having more than one use.
Got it.
So in any way of adding to any use on there is messing with the site, and so we can condition it as we want. And that's the difference of opinion between.
The two, and
The
so
two.
any variance of encroachment or anything like that would bring in more non-conforming, which is why we're asking for
Yes,
removal.
any change in the site is expanding it, and they would say, oh, we're just getting electric, and staff would say, well, no, you're building infrastructure. It's not like we just put a new circuit in and it's all in the building. It's this new stuff that was built. And those are the two, I think, competing interests, I think, there.
And with the EV unit station, part of that was encroachment, right? Or was it not? Or was it just asking for?
There may have been a little bit of, I can't remember on that. The actual stations themselves being too close to the road, yeah.
Because that's
may
what
be
I
the
thought
case.
brought,
May
elevated
have
the
been one of
variance.
them. Yeah.
One of the elements, let me say it a better way, that brought on am I going in the wrong direction? So I was trying to think, what else was it? Wasn't just EV stations alone. I thought it was some other things that brought it into need for a variance.
Yeah.
Okay.
Any other thoughts? Yes, ma'am.
Yes, I have a thought too, from what I understood from the two attorneys, that they were questioning about the lease, and of course, from OPD's point of view, the billboard being non-conforming, and to the fact that the UDC has long endeavored to remove billboard use. And I see in their timeline in 2016, which was well within known time of UDC trying to remove billboards, they acquired the leasehold. So they knew that they were acquiring something that that the UDC was trying to, over time, remove. It's not that they entered into this not knowing that sooner or later, sometime, the billboard would go away. I just had sensed an argument that there was a not understanding that the billboard at some time would need to go away. And am I missing something on that? Okay.
So the change, the only change here was the installation of the EV units, right?
Yeah.
Which, it kind of makes sense to me that just because you install something on property, you're not changing the use. It doesn't, just kind of using my common sense logic, you're not really changing the use of the property. install something on it that coincides, that ties into and facilitates the current use. So we haven't changed the use of the property, the way it seems to me.
Yeah, and,
So-
yeah, in addition, the UDC's initiative to remove billboard usage predates whatever else, because it's a non-conforming, it's been established that it's a legal non-conforming use, but that at some point in time, the goal was to remove that use.
Yeah,
Your argument is that nothing really changed with the
nothing
property.
changed, right?
Does it change, let's say, I hear what you're saying. So let's say all they did was build another 20,000 square foot building for trucking. Same thing they were doing, but they expanded it. Would that change your thought on it? Because I mean, what you're saying is like, it's hardly anything. It's just some little things that stick out of the ground. It still looks basically the same. Would that be accurate kind of for what you're thinking?
Well, yeah, I mean, if they were building a whole new building,
Right.
you know, then you've got, there are procedures you've got to go through, and that's not something that they could just do without dealing with the county at all.
Yeah.
I think that would be, something, that would be expanding the use or something that we could kind of, sink our teeth into and use as a reason to get to the sign. But this, I mean, just installing something small like this, when you don't need, I don't think you need permits, or you don't have to go through, or you do need permits.
Oh, yeah, that's why we're here.
Yeah, okay.
They couldn't just put it in. They had to get permits to install the infrastructure.
But
Yeah.
That's right, yeah.
I kind of agree with you there. I mean, I see a valid argument there of, there's one thing to add or build a brand new building, but this is servicing fleet. So let's say you had to charge forklifts outside, and you put in charging stations for forklifts. Would that make this any different? Is that a different use? Because that
Well-
use is helping their warehouse business.
I don't think the issue is the issue is not the charging units or stations, whatever you want to call them, because that's a legal, that's a use by right, just by the zoning. The problem is the billboard itself.
No, I disagree with that.
That's what's triggering.
But that's what's
The
triggering.
problem is that they increase nonconformity on the site
Right,
by building something new.
yes.
And so that in itself is what triggered it. Need to go to Varianceville.
Yeah.
I just don't.
Like, to me, I kind of see your point. Let's say if all we had were plugs on the outside of the building,
Right.
that to me seems a little different than this, where it isn't really even attached to the building. It's a separate part over to the side. It seems a little more like truly an accessory as opposed to like plugs that, are on the building. But I hear what you're saying, like,
But then you bring in, again, their point of it's not for the public's use. So that also factors it into that. I mean,
yeah.
it's difficult.
Yeah.
I see both points of both sides, but I also say, okay, what's an 18-wheeler? That's what their primary business is, moving people's belongings, and they're charging these because that's the way that the future of these vehicles are going. I don't know. In my mind, that just leans more towards a part of their existing business.
But this is what I'm meaning by the fact that it's legal non-conforming. No matter what changes you do, the status of legal non-conforming, no matter what you do, triggers.
Correct.
That's the fact that the non-conforming part is the billboard. No matter what they were doing, it was going to trigger it. No matter what they were doing.
I guess it's getting back to my point, was the original charging station request, did it trigger an additional variance? Because it wasn't just so much of putting them on the site. Did they not, like if they encroached somewhere, or was it part of that? What initiated the use of the variance besides the billboard nonconformity? But I thought there were other elements to that would have triggered this is a nonconforming, because again, just installing it alone by right, but if it encroached into the front yard setback, or if it was too far to the street, or what else prompted that, which triggered the, okay, this is not conforming, now it needs to be removed?
Was it
That's the
because they were
argument.
labeled as stations instead of
And
units?
units, and it may have been that, so that's kind of what we have to get
If
some.
if I'm reading all this correctly.
And that's to me, that's more legitimate argument than just,
Yeah.
they could do what they,
Yeah, so I think it's more what triggered
Right.
that. I mean, we knew it was legally non-conforming, but obviously there was enough, not just saying there was, units or stations, something else triggered it on the site that raised the non-conforming, oh, now we have to remove this because now we have multiple. So obviously, like I said, either a setback, and I can't remember, so I'm trying to, even ask the question, if I can, remember what else triggered.
The applicant painted the picture that they filed for a variance because the installed devices were labeled as stations instead of units. And I get that, but I see you're wondering if there was something else too, or if that was the only issue.
If that was the only issue.
They didn't even file for the variance. It was the installation company for the charging units.
Does staff remember whether or not they're, some of these, like, according to the site plan, they're like in front of the pole of the sign. Was there a issue with front setback at the time of that original case?
No.
Okay, so the sign setback is from the, not from the pole, but the vertical space or that it takes up. Does that make sense? 86, they got a variance. For
The rules may have been different. I'm not even sure
Okay.
they need the 86 variance.
Gotcha, okay. So I think what you're saying is the question for y'all is whether or not you think the amount of improvements they did should really be considered, triggering. Yeah, okay.
Got a quick question.
Yeah, go ahead.
Mr. Chairman. If staff could, can you talk about the justification of the unusual characteristics or the practical difficulty? How strong do you think the applicant's points are on that?
I'm sorry, can you repeat the question?
Just the finding of facts for this variance. Can you talk about the strength of the unique characteristics of this site, what the applicant is pointing to, or the unusual characteristics of it, to justify the variance?
I would just say as staff, we disagree with the applicant's responses to the findings of fact. Just again, based on our interpretation of the code, as well as the previous variance being reviewed and issued, we disagree that there is any practical difficulty or undue hardship that would justify going back on the original recommendation from 2023.
Other thoughts? Okay. I assume you're all ready to vote. We're already out of discussion.
As I understand it, you identified the staff as opposition earlier, and I respectfully request the opportunity to make comments in
Y'all wanna
response to
open
the
up?
staff opposition.
Yeah. No, thank you. Yeah. But respectfully.
Pardon?
Respectfully, no, thank you. Okay, so we got a vote yes on this let's think about this. As conditioned by staff, it just moves the lease date out, leaves everything like it is. A vote no would not do that. But what if, let me ask, if we wanted to make a motion to just remove number one entirely, we could do that. We just need to change our motion.
Yes, you could amend the motion.
Okay. Is that what people would like to do? So make the motion we're voting on to basically just remove number one from those conditions. That would make the most sense to get them, they're either gonna get what they want or they don't get what they want. Yeah, and if we vote no, if you end up voting no against that, then they have their regular conditions. You know, with that change right there, we're giving them exactly 2 days. So it's not really doing a whole lot. So, you know, they really kind of either need to have it or not have it. So that would make the most sense. Okay, so if there's no opposition to changing our motion, so the new motion will be, we're voting on these conditions, but without number one. Yeah, just 2 and 3. So basically, we're removing number one, is what the vote is. A vote yes removes number one, removes the need to remove the billboard.
Mr. Chairman, just for the record, could you remind me who made the motion and who seconded?
I believe it was Mr. Claybrook and then seconded by, vice versa. Okay. Okay.
Thank you.
Oh, gotcha. You seconded. Okay.
Thank you.
So, Mr. Chairman, the result would be they can keep the billboard, but they can't do the EV charging.
Well, the EV's already there, so it would just not be a condition at all. They get the EV and they get the billboard is what a yes vote will do. A vote no is they get the EV, but they're still stuck removing the billboard. I think it's really interesting. I mean, it's a very interesting case.
Let me ask this question,
Yeah.
since we are leaving number 3, so is that leaving the billboard a non-conforming off-premise sign, so therefore if we get another situation where there's some type of trigger.
Change and, it would be, they'd be right back there. Like, if we voted for them to keep the billboard at this point, if that was the vote, the 4.9.15 and number 3, that doesn't affect that, right? That's just how they're supposed to keep the billboard. I just want to make sure that that's not.
So the current amendment to delete condition 1, correct?
Delete condition 1, but what does condition 3 mean?
Okay, so for condition 3, if the current amendment is to delete condition 1, you would want to delete everything after code. That way it would remain non-conforming, but because condition 1 is gone.
Gotcha. Yeah, okay. But that section number doesn't hurt us.
No, that's just saying the situation remains non-conforming.
Okay, so without.
Just making clear that we're not granting any billboard.
Without objection, is everyone good with, as far as this motion, removing everything after the word code? So, since there's no condition 1. Okay, so that's what we're voting on. Any other thoughts before we vote? I think if we vote no, it'll go to court. You know, I mean, there's some like real legal, interesting stuff here that, like, honestly, a court has a better grasp on than we do. And I appreciate y'all trying to share that with us. Very interesting. Okay. If no other thoughts, we'll have a roll call vote.
So just to clarify, I'm sorry. So, Mr. Chairman, can you repeat again, a vote in the affirmative means?
An affirmative vote means, without looking at that, they can keep the billboard and they can keep the EV.
Okay.
A vote in the negative is they can keep the EV, but they can't keep the billboard.
Okay.
Yeah.
So we're just voting on the amendment right now, then, right? Amending to delete condition 1 and amending to delete after code.
That would be, that's what we're, yes, sir.
Okay. Are we ready?
I think we are, yeah.
Ms. Scurlock,
Yes to the amendment.
Mr. Love,
Yes.
Ms. Conrad,
Yes.
Mr. Claybrook,
Yes.
Mr. Campbell,
Yes.
Mr. Bruce,
Yes.
Vice Chair Savage Selden,
Yes.
and Chair Rainey.
I'll be the sole no.
Okay. So the amendment, so the amendment passes.
So we're just, I thought we did that. You're saying just we're voting to amend our motion?
Yes.
Right.
Oh, yeah, then yes, sorry. And so now
Oh,
give us a roll call
sorry.
vote on the actual thing. I'm sorry about that.
Okay.
I was
You're
confused.
now,
Yes.
So basically, right, so now we're voting on the whole case, and it's
Yeah.
really, condition 2 is number 1, and condition 3 is number 2, and it ends after the word cover.
That's correct.
Okay. Is there any discussion?
None.
Okay. Ms. Scurlock? Okay, Mr. Claybrook?
Yes.
Ms. Scurlock?
No.
Mr. Campbell?
Yes.
Mr. Bruce?
Yes.
Ms. Conrad?
Yes.
Mr. Love? Oh. Vice Chair Savage Selden?
No.
And Chair Rainey?
No.
Motion fails.
Motion fails. Wow. We don't get many 4-4s. Oh, whoa, hold on. Did he like? I don't want to call it then. I want to hear his vote. Hold on a second. We got one more vote. Because you said Mr. Love didn't vote, correct?
He did not.
I think he had to step out for a second. I'm not sure what happened. Yeah, so we'll just hold tight.
What is the current vote right now?
The current vote is 3 to 4. 4 in the affirmative, 3 in the negative right now. All right, we're just waiting on your vote. Sorry.
Yes.
Yes. Motion carries.
Okay, motion carries.
Yeah. That was like exciting, so yeah. So,
Thank you very much.
yeah, thank y'all. All right, y'all.
Thank you for the consideration.
Yeah, all right, y'all have a great day. All right, we're gonna hear the next case now.
Item number 4, BOA 2026-9 at 4311 Faro Drive.
All right, is the applicant present for the Faro case? All right, if y'all will come down front, please. And then, is there any opposition on this case? Okay. All right, if you can give us a brief staff report, please.
Good afternoon, Mason Ostadnia with DPD. So this is a variance for a driveway extension and a parking path setback that is less than 50 feet. You can see the location of the subject property, and this is the vicinity map. The property is located in R8 zoning district, and it is located in a residential single-family district. Here are a few pictures of the property. On the top picture, you can see the house in the middle is the subject property before any of the changes, and the one below is after they changed. As you can see in here, this has been a 2-car garage, and there is a permit associated with this BOA case that the applicant wanted to enclose this and attach it to the house. And since this has been illegal work and the permit was applied after the work was done, an additional paved parking area is needed because of the closure of the garage. And staff believes that we also can see other pictures of here as well. So also the applicant installed a fence here. And also, as you can see in the previous picture, there is no added porch, and the applicant also added a porch here without getting a permit. The applicant is required to file a demolish permit for removal of this, as they agreed on removing it. And that's why we didn't include it in the variance. And also, this is the site plan that the applicant provided to us. Overall, we believe that this is a self-created situation that the applicant applied illegal work and caused the hardship. And this is a justification of their illegal work. Per that conclusion, we believe that this is not a consistent use, and it is going to be detrimental to the public good, and we are rejecting it. Though if it's approved, it relies on the board decision. That concludes my presentation. Happy to answer any questions.
Okay. Are there any questions for staff? And so so what they're wanting to do, the new drive, like, can you go back to the site plan? Yes. They're wanting to install concrete on the red hatched area. Okay. Okay. All right.
Work hasn't been done.
Work has not been done yet. Okay. Thank you very much. If the applicant will come forward, and if you'll give your name and address for the record.
Yes, Adriana Bernadac, 4311 Faro Drive, Memphis, Tennessee, 38128.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Okay, go ahead and share with us.
Yes, sir. Like she said, that is correct. We did some illegal work that we're now trying to obtain permits for. And upon closing the garage, because my son hit it with a vehicle and it was cheaper for my husband to just replace it rather than get another garage installed, he closed it off, but we use it as storage. Basically, when we were fined, and now we're going to court for that and getting that fixed. But upon that, we were told that we needed to get a variance in order to get the permit approved for the closing of the garage, and the variance was to extend the driveway 20 feet to the left, which is like right in front of our front door. So it wouldn't harm or do anything to our neighbors because it would be like on our yard, but that's why we requested the variance.
But you could still get a permit for the garage, you just can't have the driveway, the new driveway, right?
The permit will not get approved unless the driveway gets extended 20 feet to the left.
That doesn't, I think we're misunderstanding some things.
Wait, there's one minor clarification.
Yeah, okay.
So by enclosing the garage itself, even the existing driveway would need a variance. So there are kind of two halves here, if that makes sense.
So we will give, so we need to approve something no matter what. Does that make sense?
Or you don't have to.
We don't have to, yeah, but they need, their current driveway as built would need to be approved.
Correct.
Okay, right, thank you. That makes sense.
Okay.
Are there any questions, though, for the applicant?
I have a question.
Yeah, go ahead.
So, I mean, we can agree to approve the driveway as opposed to agreeing to extend it to the front of the house.
Yes, you would have, that would be your choice.
Okay, that's the board.
I have a question for the applicant. Have you looked into the cost of, I guess you have, but can you talk about the cost of turning it back into a garage? What does that look like?
Yes, sir. We've looked into the cost, and putting turning it back into a garage would be like about $3,000 per my husband. 3,500. Yes, sir.
I don't understand why closing off a carport would trigger a driveway being relocated?
So it was originally a garage, but essentially by closing off the garage and making it part of the house, they've created the original driveway now becomes an illegal front yard parking pad for the code.
And why is it legal if it moves over? What makes it more legal?
Oh, no, it would be even less, it'd be even worse.
So they need they're really asking for 2 variances today. Or not, but the first one, because they don't have a garage that the driveway's leading to, it's not a driveway anymore. It's a parking pad as built. So they need a variance for a parking pad.
Understand that part.
Number 2, they would like to add more parking pad in that red area.
But why? Is it just
To park.
Gotcha. But the code enforcement office is not saying shift it over.
Okay.
No. Correct. Correct. They would be able to get their building permit based on us solely saying, yes, you're allowed to have the front yard parking pad as built now.
Gotcha.
Right.
Well, I don't,
You're just wanting more space to park on the property, correct? Okay. How many cars are y'all trying to park?
We have 4, which they fit at the driveway that we have now.
Right. Understood. Parking pads have become very controversial. You know, a lot of people are wanting more and more parking because people think it's safer on their property than on the street and stuff like that. But the code is very clear on what parking pads are allowed, which is kind of why you're here.
Yes, sir.
So it's kind of a tough deal. Any other questions for the applicant? Okay, thank you very much.
Thank you.
I'm going to ask, is there any opposition to this case today? Didn't think so? Okay. Let's see if we can get, I would like us to do a motion to approve a variance for the existing driveway that is now a parking pad. And then if we want to do another motion for the other one, we can. But we'll start there. So I'm going to take your agreement as a second. I'm sorry, as a motion. A second. And then we have a second from Mr. Campbell. Correct. Okay, is there any discussion of the first driveway being allowed? First parking pad. Okay, let's go ahead and vote on that one, if that's okay, Mr. Penzis.
That says is it currently?
That's we're approving only the existing driveway.
Okay.
And then we'll move into the additional parking pad.
Okay, gotcha.
So we're moving to approve additional driveway as a parking pad.
Okay, so we'll take condition 1 and then could we maybe write condition 2 just to say something like but then if I make a condition that says that it can't be expanded. Should we vote on the expansion first?
We can.
Because it might be simpler if we do the expansion.
Why don't we,
I move to, well, how do we move that?
Or we can just keep it all as one motion, and then you can make amendments to the condition to see if anyone's interested.
Okay, so what you're saying, so you would like us to table our current motion,
Yes.
and then we will make a new motion, just conditioned by staff for us to discuss.
Yes.
Okay. All right. Would y'all be okay with that being your motion?
Mm-hmm.
So moved.
All right, so moved and seconded. Okay, so the discussion really is probably,
Sorry, I missed the second. Who seconded?
I did.
Mr. Campbell, I think our discussion we have is, are we going to have the votes to add in the larger space, the red? Like, how does the board?
I totally think that's all. I wouldn't want to do that.
A bridge too far.
Yeah, just because, sometimes you got to just protect from yourself sometimes.
Okay.
It's right in front of your front door.
Is there anyone a counter argument to that by anyone on the board?
No.
Okay, so then would we want to vote let's move to amend our motion to remove the red area from the variance?
Or you could just make a condition essentially that says the existing driveway
But not the proposed
may
driveway.
remain, however, it cannot be expanded. I think that would cover it.
Okay,
And we just make sure to get a revised site plan.
okay. So what Jeffrey said. So do we have a problem with amending our motion so that it is that we're allowing the existing driveway but without expansion?
No objection.
No
No
objection.
objection, okay. So we're good with just voting on the whole thing?
Yes, yes.
Not voting on the amendment to the motion, correct?
I didn't hear any objections.
Okay, very good, okay. All right, so if there's no discussion, let's go ahead and get a roll call vote.
So
Mr.
an affirmative vote means we're good with how it's currently.
As built, being a parking pad, yes.
Gotcha.
No red area.
Yeah.
Okay. Ms. Conrad,
Yes.
Mr. Love,
Yes.
Mr. Bruce,
Yes.
Mr. Love,
Yes.
Mr. Campbell, Mr. Claybrook,
Yes.
Vice Chair Savage Selden,
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
and Chair Rainey.
Yes.
Motion carries.
Okay, so you guys have been approved to have your driveway as it is, but there's no expanded driveway. So you can't build the red, but go and get everything permitted. Thank y'all. If we could call our next case we're gonna hear?
Item number 5, BOA 2026-13 at 6901 Mount Moriah extended.
Okay. The applicant I see is present. Is there any opposition to this case today? All right, seeing none. All right, if we could get a staff report on this Mount Moriah case.
Good afternoon. Kendra Cobbs, Division of Planning and Development. So this is a variance request. The applicant is Rover Signs and represented by Bacchus Urban Design Group. And it is a request to allow an off-premise sign or billboard that's not located within 300 feet of an interstate highway. And also there is a variance request for the height of the sign. Looking at a quick case summary, so as I mentioned, the applicant would like to place a sign at 6901 Mount Moriah Extended where it is not allowed because it's not within 300 feet of a highway. Also, our Unified Development Code explicitly lists locations where billboards can be located, and those are in our commercial mixed-use 3 district, CMU 3, Central Business District, Employment and Heavy Industrial Zoning District. This is Zone CMU 3, so it does meet that requirement. However, with number 2, it's not located along a U.S. highway. Another standard for billboards is that there is legal access from a public highway or street. And lastly, as we learned in case number 1, does not share its lot with any other principal use. In addition to adding a billboard to a site, there is permitting that is required at the state level. So this is from the Tennessee Code, and it is their regulations and control of outdoor advertising. And it states that even if a property is zoned commercial or zoned industrial, that means that there have been comprehensive zoning that has allowed that, local zoning regulations. However, but that does not include strip zoning, spot zoning, or variances granted by the local political subdivision strictly for outdoor advertising. In this case, that is the request. Also, the applicant would like for the billboard to be a height of 91 feet, and 75 feet is the max height requirement for the zoning district. So also within the staff report on page 24 in the staff report, there is a resolution that City Council passed in 2022 Because of the proliferation, overabundance of billboards, they passed this resolution requesting DPD to study incentives for removal of non-conforming billboards. And as that resolution states, billboards have been recognized as contributing to visual blight. And so these are just pictures throughout the city of where we have non-conforming billboards already. We have on Lamar and Democrat, it's actually legal non-conforming. Also Poplar and Alicia, this site actually has 2 billboards. On the upper right, we have a billboard on Winchester and also Lamar. Those are 2-sided billboards. So that just goes to speak to some of the locations where we already have so many billboards. So this is located in the Hickory Hill area, and we did send out public notice of this request, 187 notices on March 5th, 2026. Looking at the zoning map, as I mentioned, it is zone CMU3. Surrounding zoning is residential, and then we actually have conservation agriculture, which is to the southeast of the site. And looking at the land use map, we have the neighborhood that is to the south and the west of the site, marked by the star. To the north, we have office uses, and then commercial, which is the shopping center, Cross Creek Shopping Center, that has Home Depot. And that's at Ridgeway Road. These are some views of the site where the billboard is proposed. And this is the site plan that the applicant submitted. The site is highlighted in yellow. So to conclude, the request is for another billboard, and it's not located along interstate highway. And the nearest interstate is 240, which is about 4.5 miles away. The request was also made that this billboard would exceed the maximum height limit. Our Unified Development Code strictly limits placement of new billboards. And so, as I mentioned, in 2022, City Council did adopt a resolution requesting that DPD look to limit and have a study on where the non-conforming billboards are located. Within the application, there were no unusual characteristics of the property. There are no exceptional physical features of the property that have been proven by the application that deems this to be an undue hardship or practical difficulty. So staff finds that granting approval of this request would be substantially detrimental to the public good and also impair the intent and purpose of the Unified Development Code. And the billboards, as we see, it's just another representation of we have as many as this community needs. So we are recommending rejection. However, if approved, staff is recommending the following conditions. And that concludes my report. I'm happy to answer any questions.
All right, are there any questions for staff?
The billboard that you showed on, is that Winchester? Is that one off of the 385? I think it's non-conforming, but is that one off the 385 view? I can't remember.
No, it is not. It's a non-conforming, legally non-conforming billboard. I was trying to get back to that slide.
Yeah, I was trying to look and see.
Here we go.
Did I see, and you may have said it, did I see somewhere where, like right now on 385, there's like one billboard?
I did look. I did not find any that were specifically on 385. It could be.
Sure.
but I wasn't able to find it. We did have a billboard layer where we could quickly locate where they are, but that no longer exists. So.
Saw that somewhere. Okay. All right. No
Mr.
worries.
Chairman, I think one of the letters submitted in support mentions there is a.
That's where I read it. Okay,
advertising.
okay. All right. All right. If there's no more questions for staff, we'll move on to the applicant. Mr. Bacchus, you want to come share with us? And if you'll give your name and address for the record. And if you're both going to speak, if you'll both go ahead and I'll swear you both in.
Yeah, thank you, Mr. Chairman. Brian Bacchus, Bacchus Urban Design Group, 5320 White Diamond, Memphis 38109.
Okay, are you the, well, we'll get him in a second. Do you swear to tell the truth, the whole truth, and nothing but the truth, so we got it?
I do.
Okay.
Mr. Chairman, for all practical purposes, I will be presenting this case. Mr. Prentice, who's the applicant, Rover Signs LLC, he wants to share a video with you to kind of take you out to the site, give you a site visit of what's going on here.
Okay.
To try to see exactly where we are in the world.
Okay.
So we're probably about 20 minutes from here.
Right.
Mr. Chairman, we do not have this on a jump drive, so I am not sure how I'll be able to show this
Okay.
to the board.
Okay.
Looks like we have a flash drive. We may be able to get this.
Okay. Y'all can work on that. And Mr. Bacchus, you want to go ahead and give your, if you want to start, we can come back and we can get the video to work.
Thank you, Mr. Chairman. Just want to verify that that's the #1 presentation in my presentation folder.
Oh, okay.
Yes, that's it. Thank
Okay.
you.
Very good.
Thank you, Mr. Chairman. We're here today, Mr. Chairman, to request two things. Two things. This property is zoned commercial mixed-use district. It permits an outdoor advertising sign. That's one. Number two, we're asking for the location. We're asking for a variance to the location. Number three, we're asking for a variance to the height. That's why we're here. Otherwise, Mr. Prentice could go out and build a billboard today if we only had those two, if we only met those two criteria. That's why we're here. So in order to explain that a little further, I would like from Ms. Cobb and Ms. Atkins, who's with me as well, just kind of give you an overview of the site from what we've looked at from a planning perspective.
Okay.
Next slide, please. This is a view of the property. To your left is looking southeast toward Cross Creek Center. In the middle is Mount Moriah Road, where Mount Moriah dead ends into this property. It dead ends. Public street frontage access. To the right is where is along the 385, Along 385 is a right-of-way, along 385 right-of-way. Next slide, please. And here is the subject property photos where you have the outdoor sign location on the left. To the right, Cross Creek Center. Keep in mind, Cross Creek Center is a planned development. However, the underlying zoning of that property is CMU3, which is the same as this property. Next slide, please. Subject property view from 385. As you can see, the site is kind of out in the open field. This is 385 going southeast toward Collierville, right at the Riverdale exit sign. As you see the Riverdale exit there to your left. Next slide, please. Tennessee 385. All along Tennessee 385, there are similar vertical structures. You have billboards are vertical structures, just like cellular towers, just like TVA towers, just like transmission lines, just like power poles, just like overhead parking lights. These are vertical structures. They're permitted in most places, all day, every day. As you can see to the left is an outdoor advertising sign that currently exists along 385. To the right is the same sign that shows the location of how it's viewed, it's visible from 385. This is the on-ramp from, I believe, Riverdale, as you're going southeast toward Collierville. And there's a cell tower to your left, there's a cell tower to your right, there's a TVA easement in the background, you can see it. There's a TVA easement that runs along the north side of 385 all the way. And there's also a TVA easement that traverses this property on the eastern portion. And we'll show that later. Next slide, please. Another view. This is a close-up view, has a cell tower, vertical structure. In the background, cell tower, vertical structure. Then you have Tennessee 385 on our outdoor sign, which is there today. Was approved not too long ago, maybe about a couple years ago. Next slide, please. This is an outdoor advertising sign that's right here downtown, right just north of us, off of 2nd Street and I-40. It's viewed from I-40 going west. The advertising on that billboard, St. Jude takes advantage of it, the downtown Memphis Commission takes advantage of it. This is an advertising sign, outdoor advertising sign that allows people to know what's going on in the downtown area. It also allows people what's going on in the West Memphis area and any other advertisement that they may choose to put on the placement of these towers. On the placement of the billboard or outdoor advertising. I don't like to call them billboards because that's not technically a name. Next slide. This is a view, is what it might look like along this section of the highway. We tried to impose this graphic to kind of match the office buildings that's adjacent to this property. It can be done. It can be done. It doesn't have to look like your typical outdoor billboard, outdoor advertising sign. It can be cladded with some type of limestone or granite, and it will look similar to that. It has to meet wind loads and all this sort of thing. So it can be done. We have structural engineers that do these kinds of things. And this is approximate location of the sign. Next slide, please. That's the end of that slide. Number 2 kind of goes into the findings of fact for this case. Mr. Chairman, how much more time do I have? And I'll just continue with I have some copies of the presentation.
About 5 minutes.
Do you have the copies of the presentation?
We do have copies of the presentation. Yes.
Thank you. So if we could go to the presentation, Ms. Kendra. Ms. Kendra, can we go to the presentation? Thank you. Number 2, it's number slide. It's presentation 2 on the jump drive. So, of course, we're here to talk about the subject property. The next slide is for the aerial photo view. It gives you the location of the site. As you can tell, there's a office, Lenox Park office to the northwest, Cross Creek Center to the southeast. These are existing developments approved by planned developments. However, they currently exist today. And this site is anchored or bookcased by both of those. Next slide, please. Subject property is 22 acres, almost 23 acres, large parcel, stands in isolation to the adjacent neighborhood and adjacent developments. Has 1,000, almost 1,100 feet of frontage on Tennessee 385, and the partial has access to Mount Moriah Road extended. Requested variances, as I stated earlier, location and height. That's all we're asking for. Next slide, please. This is Lenox Park East. These are final plans that have been recorded with the Shelby County Registrar's Office that gives you the dedication plat to the left of Mount Moriah extended. To the right, you have the final plan for the office complex, one of the buildings in the office in Lennox Park. On these plans, it shows that this plat has an easement to this site. They would not, I believe the owner of this property would have never let this happen if he did not have access to his property. Mr. Mitchell does not own the property. The owner of this property would not have, he's in the land development business, he would not have let anyone do anything without having him access to his property. So he has access. Next slide. This is a land use map. It shows the land use in the area, vacant property, Lennox Park, all the commercial along Winchester, and to the southeast along Riverdale Road. And there's also the other Tennessee 385 outdoor advertising sign just to the southeast of this property. It's over 2,000 feet away. There's one there today. You saw it in the prior photos. Next slide, please. These are the centers next door. Lennox Park, upper left, Cross Creek, lower right. Next slide, please. And this is the same slide from the original view from the photo shoot that I gave you. This is an existing outdoor advertising sign that's currently out on 385 today. Next slide, please. Hardship, practical difficulty. The property is unusual and it exhibits an exceptional triangular shape and exhibits significant topographic conditions like other properties in the district. Same properties had the same issues. The property exhibits a practical difficulty by limited in access to circulation compared to similar properties in the vicinity due to the dead-end nature of Mount Moriah with no direct access to Tennessee 385. You can't have access from Tennessee 385. It's a controlled access roadway. It was not self-created, unique conditions. It's encumbered by a major MLGW transmission easement to the east, 200 feet wide, and almost entirely located within the 100-year floodplain. Next slide. This is a zoning map. Shows you what the zoning is in this area. Even though you have buildings on these sites to the southeast, you see the zoning is commercial mixed use 3. Hence the argument about spot zoning. CMU 3 is there. It's been there for a long time, since 1980 I know of. And also this property is zoned CMU 3. So it's not spot zoning. It's adjacent to CMU 3 zoning. How is that spot zoning? I don't know. But that's where we are today. And if you see the floodplain and the floodways that encumbers the site, you see the floodway district to the north that runs parallel to 385. This area, this elevated roadway took about 10 years to construct. I remember it. There was digging and borrow pits everywhere for fill, to build these bridges, to build the roadways. I remember every bit of it. So I experienced it in the field. So, but this area is encumbered by MLGW easements, transmission easement, vertical structures, towers, and the like. Next slide, please. Findings of fact. Minimum variance necessary. The requested relief is a minimum necessary to allow the use of the property. It's consistent, no detriment to the public good. It's compatible. Conditions, we're okay with the conditions if approved. Next slide. And the benefits, it implements the intent of the UDC, enables reasonable use of the property, it limits relief for the minimum necessary for granting a variance, protects the public interest, supports major corridor-oriented economic activity, without introducing incompatible land use. Next slide, please.
All right, let's wrap it up, but we'll have some rebuttal time.
You have the presentation. So, yeah. But these are the marketing advantages and aspects of this. It's favorable demographic district, significant daily commuter traffic, high visibility, less clutter. Summary: Tennessee 385 combines traffic volume, visibility, and target audience, making it a highly marketable and valuable location for an outdoor advertising. Okay. Mr. Chairman, I know I don't have many more time, but Mr. Mitchell has state-approved permits for this site. He has 2. One is before you today. And he's asking your indulgence for the approval of this outdoor advertising sign for 2 variances, location and height. We're not talking about use here. We're not talking about use at all. We're talking about variances. It's not a use variance. It's a variance. So that's where we are, Mr. Chairman, and I thank you for your indulgence, and I thank you for the extra time.
All right. Are there any questions for Mr. Bacchus?
Mr. Bach.
Go ahead.
Mr. Bacchus, real quick. Now, I know you heard the other case, and we do them case by case, but are there any other forethoughts for other uses to this property in addition to the sign, marketing sign?
I have not spoken to the owner of the property. I'm not sure what his intentions are. However, this does not negate any other uses from going on this property.
Thank you.
I got a question for staff. What is the general rule for new billboards to be considered conforming?
Oh, basically you have to meet all the standards of the Unified Development Code, and probably the most specific one here is that it has to be on a U.S. interstate highway, and this is not a U.S. interstate highway.
The standards are section 498, it's 1 through 4.
It's Tennessee State Highway. It's controlled access, but not an interstate. Any other questions? Okay. I think we have a little, I don't know if we really have rebuttal time. Do you have any rebuttal, like, or closing, do you need a closing statement? We normally would go to, because there's no one here in opposition. You normally get 2 minutes of rebuttal, but I don't know if there's.
The only thing I'd like to say, Mr. Chairman, and I thank you for that time, is that keep in mind, this project should stand on its own. It should not be compared to other legal non-conforming billboards in the city. This is not a legal non-conforming structure as of today. However, the applicant is asking for 2 variances to be located along a Tennessee corridor that serves and acts as interstate highway, and also to increase the height to approximately by 15 feet, which from 75 to I think 91. So that's where we are. There are 4 letters of support, and I think you also received those as well.
Yes, sir.
From businesses in the area. They are in need of outdoor advertising. And I just want to make this point clear as well. This is a technology corridor. It's always been designated as one. However, this concept has not been pushed by the administration like it should have been. That's just my opinion. It's not a fact, my opinion. That's why we have FedEx headquarters out here, is because this was a technology corridor. That's why, it's exactly why we have it. Everyone in this corridor could benefit from this location. They could advertise anything that's going on in Germantown, the horse show, anything that's going on in Collierville. I can't remember the name of the festival they have out there every year. But these kinds of things can be advertised on an outdoor environment. So just want to keep in mind the broader sense of this is much bigger than what these 2 variances. It's a much broader aspect. An outdoor advertising sign has many benefits from the city as a whole. Even though this is located in the southeast portion, everyone can benefit in this area from an outdoor advertising sign. Amber alerts, senior alerts, weather alerts, all kinds of things that can be placed on outdoor advertising signs. So I just don't understand why we so adamant against outdoor advertising signs when we have them all over the nation. Okay. They're all over the nation, and they are a permitted use in certain locations. So the zoning does not prohibit them. We are at a standstill when it comes to legal non-conforming signs, and I understand that. I know I'm rattling, but I thank you for your time.
All right, thank you, Mr. Bacchus. All right, if we could get a motion to approve BOA 2026-13 as conditioned by staff.
So moved.
Second. So I'll take Conrad and Campbell. Discussion. I think we ought to start our discussion before we get into the height. If we are against the location, there's no reason to talk about height. I don't think so. Or I don't think so. What are your thoughts on whether we should grant a variance? Yeah, I think what we're trying to weigh here is City Council's passed resolutions that allow billboards now only allowed U.S. interstate highways. It was very specific that it said that. It didn't say, I mean, that's what they used to define it. This is not a U.S. interstate highway, although probably a lot of people don't know that. You know, I mean, it feels like an interstate. I'll grant that, but it is not an interstate highway. And so I think what we need to struggle through is whether or not we think the legislature was intentionally specific, or if they were trying to give us the type of road they wanted around. And so I want to hear your thoughts on that.
Okay. I did not know 385 was not a U.S. highway.
Yeah.
This is one of those strange scenarios where, because I thought it was a U.S. highway, I'm pretty sure I'm not pretty sure, but it seems when they wrote the legal doctrine for that, the intent was the type of road it was on, not a typical street or. So I can understand why they would say U.S. highway and exclude 385, not really thinking about all the individual exclusions that happen. I think in Memphis, it might be 385 might be the only one of few that will fall in this category, if I'm correct.
As far as a controlled access highway that's not an interstate?
Correct. Yeah.
Possibly.
But at the same time,
But it's a long, big road.
Yeah. At the same time, when the council puts these doctrines into place, I hate to be the one that just goes and say, forget what they intended, forget what they meant. We don't see a problem with it. So I don't want to set a standard for. So I'm on both sides of the fence, right? I don't want to set a standard for saying, oh, well, this is an exception to what they intended. But on the other hand, I would be curious to know if their intentions was to consider this part of the U.S. highway system incidentally.
Yeah.
Point of clarification.
We're already in discussion.
I'm with Mr. Campbell. Well, I know 385. I mean, I'm saying that, probably haven't learned that in the last couple of years. Again, not going against city council, but I think the understanding how 385 is used now, the volume, the traffic, all of that, I think most people will presume 385 is acting like a U.S. highway. It may not be labeled that, but it's definitely connecting more parts of Memphis. I would even say probably more so than the almost 240s and things, because now people cut through from 40, coming from Piperton and some of the other places, now use 385, as their means of a highway. So I know the intent is for us to clean up and straighten up, but definitely I would say probably, I don't see the harm, let me say it a better way, in that particular billboard in that position. But am I cheering on them to influx? No.
I would disagree with you. I think that the fact they wrote U.S. Interstate Highway means they mean a U.S. Interstate Highway. And if that needs to be changed, the council needs to change that. I don't know, they've been fairly clear how much they want to get rid of the proliferation of billboards. So I can't imagine them saying, oh yeah, but you can build on 385. I think they would rather us have 0 billboards in the whole town. Like, I think if they would have thought about it, they maybe could have said US Highway, not 385. You know, it's a big, long road. It goes all the way to Millington. Of course, it's got to be in CMU 3, so a lot of it's rural. But it is nice when you drive out to Carterville and don't see billboard after billboard after billboard after billboard. So,
And that was kind of my thought too. Like, there's a part of 385 that's very U.S. highway-ish, but then you get to the end of 385, more towards the other rural areas, and it feels less of a highway. So those areas, I think we might be opening ourselves up to.
Yeah, and I would say, well, first of all, like most of you guys, I'm surprised to hear that it's not an interstate, but in hindsight, I think I should have known. I was told a long time ago that the 2-digit highways are interstate, the 3 digits are not, so I should have known. But, the main point for me is, I don't know that it's our job to reinterpret or to I think reinterpret is probably the best word, what city council, is it city council, has said, or county commission, but to interpret what they said. I mean, they said one thing, and we can't decide, well, we know what you said, but we decided that you meant something else. I don't think that's our job. We have to look at what they actually said. And so I'm not, unless somebody can help me out, right now, I'm trying to find a way to be comfortable interpreting that in a way that differs with what they explicitly said.
Well, I agree with you, and the other Pandora's box that it opens up is that 385 is varied along the path, and then there's parts of it where it goes Shelby County, Shelby County, Fayette County. It alters counties, and then of course zoning. So now you may have CMU 3, whatever the zoning, right up at the Shelby County, Fayette County line, and then that impedes the residential that might be right up on that line. I mean, it's just a Pandora's box of what can happen that wasn't explicitly stated. So yeah, I do agree.
Yeah, I think some of that would be helped by the fact it's got to be in CMU 3.
Yes.
And a lot of that, like across is like conservation, agriculture, and stuff.
Yeah,
I do find the most dispositive thing that is just very specific to U.S. Interstate Highway, and they've been very clear in multiple resolutions and things like that about wanting to not only, get rid of current billboards and not have new billboards. So I think they intentionally, I don't know, but I think they probably intentionally limited it the way they did.
Yeah, and have the properties that have billboards be dedicated for just that one purpose.
Right. Yeah. Here, it's a big parcel.
Yeah,
So they
big
could,
parcel.
probably subdivide it, make it smaller, and do some of that. But I just wouldn't want to. I couldn't vote in favor of this. Any other thoughts before we vote? All right, if we can get a roll call vote, please.
Mr. Bruce.
So let me make sure.
A no would not allow the billboard.
Right, okay, no.
Are we strictly, so we didn't break it up?
We didn't, because if we're a no vote goes there, yeah.
Yes, my vote is no.
Ms. Scorlock.
No.
Ms. Conrad.
No.
Mr. Campbell.
No.
Mr. Claybrook.
No.
Mr. Love.
No.
Vice Chair Savage Selden.
Yes.
And Chair Rainey.
No.
Motion fails.
Motion fails, 7-1. Thank you for coming down, Mr. Bacchus. Yeah. Okay, Okay, Mr. Penzis, could you call our last case?
Item number 9, BOA 2026-20 at 2067 Linden Avenue.
Okay, is the applicant present? Okay, you'll come down to the front. I'm assuming we have some opposition because it's our last case and we still have people here. So, yeah, and this goes in the record, that one, yeah. I got one support and one opposition there. So what we'll do is we're gonna get a staff report first, and then we're gonna hear from the applicant, move to opposition, then come back to the applicant for rebuttal. Okay. All right, whenever you're ready, Ms. Stadnia.
Good afternoon, Mason Stadnia with DPD. The applicant is requesting for a variance for accessory structures, a grill and a gazebo. This is a location map and also a vicinity map. This property is located in RU1 zoning district, and the land use is a mixture of single-family, multifamily, and commercial. Here are the site photos. This is the picture of the gazebo. And also this one shows the grill that has been added to this property. This is the site plan that the applicant provided to us. A closer look to the site plan, we can see the gazebo here, and on the rear side we have 3 feet, and on the side we have 1.5 feet of encroachment. And also this is the grill, and there is 0 setback provided here. All in all, staff believes this is a consistent use, and also there is no substantial detriment to the public good, and we are approving this with conditions. That concludes my presentation. Happy to answer any questions.
Could you put the site plan back up? I was looking at one thing. I want to make sure I had it right. The grill, it mentioned several times in the staff report it's on the eastern side, but I think it's on the western side.
It's there.
Right, so that's the west side, correct?
Yes, you are correct.
Okay, so just as a note, everywhere it mentions the grill, we'll make sure it says western side in the, our final documents. Okay, if the applicant will come, are there any other questions for staff? Okay, the applicant will come forward, and you have 10 minutes to present to us, but you do have somebody in support if you want to leave time for them.
Okay, thank you.
Okay. Give your name and address for the record, thanks.
Yes, sir. My name is Josh Metcalf. I live at 2067 Linden Avenue.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead.
Okay, so I'm here today to request a slight variance for my gazebo and my grill. The work has already been done. I put these, we had these constructions built in 2020, back in June. And it was my fault on that because I did not know that I needed to pull a permit for these, for the gazebo or for the grill. And so my gazebo is in the southeast corner in the rear part of my backyard. It's not near any houses. It's the back, like where all of my neighbors' yards meet. Actually, I had all of those neighbors send in letters of support where the gazebo is touching their yards. And then, so I'm asking for a variance for that for the setback. It's 3 feet on the south and about 2 feet, 3 feet on the east and about 2 feet on the south. And then my grill, so basically all it is, it's a straight up wall with mason blocks. It's 6 feet tall. I was told by the contractor that put it in that I wouldn't need a permit because it didn't have a roof. It was a very simple structure. And so it's just, we put it in right in front of the fence where the fence was until the neighbors took the fence down. So the grill was there just so that we could have use of our patio. I saw my neighbor's opposition letter. So we had, I think, 5 letters of support from my neighbors. And then I saw the opposition. So I've already fixed every issue or concern that they've had in that letter. I don't really, that's pretty much all I have to say. I'm just asking for your all support on to get the variance accepted, or?
Okay, so how much time do we have? So you actually get 9 minutes. If you're gonna reserve time,
yeah,
you have more time.
Yes, sir.
Does Mr. Waldrop want to talk? That would take some time, but.
For now, and then, because I get to speak again, correct?
Yeah.
Yes.
Yeah, okay. All right, so y'all will rest. Okay. We're gonna move to the opposition. And so I have Mr. Golden, Mrs. Golden? I can't read the first name.
That's Mrs. Golden.
Mrs. Golden, okay.
And I am Byron Winsett.
Okay.
Pickler Law. I'm representing them.
Okay.
We'd like to start by requesting that you hold consideration of at least the grill to the next meeting. My clients have been made aware of this entire situation. They received the notice regarding the gazebo. The application from the applicant is devoid of mention of the grill, and the grill itself is the most directly affecting structure for my clients. They live, their driveway is there next to the grill, and that faces their backyard. So again, we're asking first that consideration of that particular item be held. They first noticed that it was part of the staff report after they had submitted their response last week.
Okay. Did the response not mention the grill?
It did not their original response. They have since submitted further response.
Okay. I thought I just saw something on it. Is
Right.
Okay.
And we've been informed that that would be considered late filed or too late to be considered.
Well, it's definitely not too late to be considered at our meeting.
Okay.
Yeah.
But also we're requesting that the delay in the consideration of that particular item because we haven't had the time to prepare an appropriate detailed response with support from citations and appropriate code.
Okay.
The situation that exists here and that came to my client's attention was in fact brought up by that fence removal. This was not a removal to destroy or remove the fence permanently, it was to replace the fence. At that time, they had a contractor hired to rebuild, to put in a new fence, and that contractor indicated that they could not proceed because of the closeness of the entire amount of poured concrete, which actually that entire area is poured concrete and goes to a depth of at least 2 feet at some places. And there is wastewater coming out of the back of that grill and going on to my client's property next door. That wastewater is just freely flowing out onto their property and is not compliant with plumbing code and this continues to cause leakage onto their property, which is rather severe and is likely to cause damage after a long period of continued use. So that is the primary plumbing concern. And then also, of course, this structure abuts their property, leaving no setback whatsoever. It's a rather large structure, several feet long, and prevents being able to put up a new fence in that area without coming on to and encroaching on their property. and is problematic. They also, as you know from their submission, they are objecting to and do not want the variance allowed for the gazebo. Really, the entire backyard structure was done without permit, without application, without approval, without any type of oversight, and causes an incredible runoff problem for their property and other properties around. It raises up and puts a non-porous surface across the property, across that entire backyard of their neighbor, and causes, obviously, therefore, excessive runoff onto the neighboring yards. And so there's in addition to that, there are electrical, there's electricity provided to the grill area, the pool pump, the gazebo area, and none of that is permitted, none of that is reviewed. They are concerned about the danger of stored combustible materials near their property as a result of the setup of the backyard. And overall, it is not a safe or acceptable use. I'd also like to allow Ms. Golden to speak directly.
Okay. You can give your name and address for the record, Ms. Golden. We'll need to swear you in.
Yes, my name is Alora Golden. I'm at 2061 Linden Avenue.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
Like I mentioned, my name is Alora Golden. I'm joined here today with my husband, Brian Nishimoto, and our families. We would like to share a statement to help frame our position as interpreted through the scrutinizing lens of the code that the board strictly upholds. We are the only adjoining property owner to the outdoor kitchen, and we experience the impacts of the structure directly and continuously, particularly drainage, hygiene, and safety at the shared property line. We provided documentations of those impacts in our submissions, including an addendum. And we respectfully ask the board to consider whether these findings, especially regarding impact to adjacent properties, can be met in this case. Thank you.
We do have copies of that addendum. I'm not sure if, it sounds like you do have that.
I think so.
Okay, but we do have the materials. If anything needs to be provided to you, we have hard copies of that.
Am I looking at the right addendum? The newest documentation they provided about the grill? I know I have pictures dealing with like the grill and showing the pipe on the back that I think they were submitted. That would be in that, correct?
That would be it.
Okay. Okay. Are there any questions for the opposition?
I got a question. I'm pretty sure it can be from either one of them. On the side of the grill, are we saying that the proposed fence can no longer go in its original prescribed location because of the grill?
That's what's informed by the contractor because of and part of the problem is that the plumbing is not correct there. So until that plumbing is corrected, the fence contractor, of course, doesn't know where they can put a fence or how they can position a fence until there's appropriate plumbing provided. Right now, if you see from that photo, it's just a pipe that comes out the back of the grill, runs a little bit of the way down the fence line. It would have previously been behind that fence, so they weren't even aware that that was happening. And then it just stops and discharges now onto their property.
I can add some additional color if you'd like. I'm the owner.
Yeah, if you would like to come get sworn in.
So I'm Brian Nishimoto, address 2061 Linden Avenue.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead, Brian.
Just really quickly regarding that question about the fence, it's an enhancement fence. So in other words, originally what was there was a 6-foot fence. What we've proposed is a 9-foot fence. So the footholds are different. due to the weight of the wood. We are also adjusting the wood from a pine to a cedar, and so it was substantially different from a design perspective.
And don't go anywhere. As far as the pipe discharging waters, I guess, is there just a sink, but it just drains to the back from what you can tell?
That is correct. Currently, there is no pipe there, but it has not been filled, which was what was advised, at least to us, by code enforcement. There is also water lines running to it. I don't know if you can see those in the image. Those are running above ground, about 12 inches over the ground. I think code requires that they be buried 16 inches.
So who's providing is the applicant the one who's providing the fence, or is it the
Opposition
is the
placing
one
their
replacing
fence.
it?
Yeah.
Okay. So because you're going with a taller, more robust fence, it has some more restrictions or requirements as far as footings and things like that.
I'm sorry.
I was saying because you're going with a taller, more robust fence, I'm assuming the installation requires a little more.
That is correct. It requires more robust footings.
Okay.
Can you have a 9-foot fence? 9 feet as long as it's in the backyard.
That's it. Okay. Yeah. Very good. Any other questions for the opposition? Okay, if the applicant wants to come back up, and if you, to rebut or explain or say, I don't want to hold, or yeah, I'd be willing to look at it for a month, that would be probably what the board would love to hear.
Yes, sir. Yeah. Absolutely. So I absolutely would request not to hold at this point. Our kitchen, yes, it is right on their property line, or on our shared property line, just in front of it, like I said, in front of where the fence was. When I put in the kitchen, this structure is so simple. I don't know, was there a picture of it so you guys can see it? Yeah, so the water going into it, I attached my hose bib is right in front. I did it myself, and I just attached my hose bib and I ran it across into the sink. And so it was just to rinse my hands off when I grill. It's not like I'm running water all the time. It's maybe once a week, once every 2 weeks. I flip a burger, I rinse my hands. The pipe going out to the back was pumping out just when I would do that into my grass, into my yard right behind the fence. However, when code enforcement came out, they told me that if there was water going into it, then I had to relocate that water somewhere else. So I have pictures of it now. If I don't know if I can show you, I don't know how this works.
You can pass them for
But I have removed the water going into it and the drain pipe. There's no more water going in or out of the kitchen. So that is now a moot point because there is no plumbing at all. I don't need to rinse my hands off that bad. So.
Gotcha. Okay.
Yes, sir. I had a plumber because if you look at their opposition letter, they also called code enforcement for another plumbing issue. I fixed that issue as well. That had to do with my pool pumping into the street, and because I live in a house that was built in 1912, we didn't have a clean out when we installed our pool, so the contractor told me, I'll do like I do for everybody else, and I'll run it through the curb when we backwash the pool. Code came out, and I fixed that issue, and I have proof of that if anyone wants to see that. But I also, when I fixed that, I asked my plumber, and he told me that it would be too expensive for me to tie into the sewer for my outdoor kitchen, so we fixed that then. Okay. Yes, sir. Yes, sir. And then as far as the permit for the kitchen, when I first started my variance application, you know, I'm very new to this. I don't do this every day. So I came up to City Hall and I asked a lady named Magali up there what I needed to do. And she told me to pull my permit for the kitchen, but not for the gazebo until the variance hearing. So I've been pulling my permit. I have proof that I have started that application process, and I'm waiting on a structural engineer letter, which is what they've asked me to get. Poe, I believe it's called Poe Engineering. They've told me that they will write the letter, but they couldn't have it to me before today. So that's all I'm waiting on to finish my permit for the outdoor kitchen. And that's all on my end. I have another neighbor also would like to say a few things.
Okay. I got a quick question.
Yes, sir.
What is the proposed finish of the back of your grill area?
So what was the proposed finish, you mean?
Yeah.
So basically, it looks ugly like that because it was just cement and there was a fence behind it, so you couldn't see it. And when the fence goes back up, you won't be able to see it again. I will propose to just put up a fence myself and use the grill as part of my fence and give them 6 inches of yard. I need a fence immediately because I have dogs and kids, and so I've been waiting since they wanted the upgrade. I've been waiting on this fence. It's been 3 months since they took it down. But yeah, I mean, if they want to paint it, if they want to put their fence back where it was, I'm happy to go back there and paint it. But yes, sir. The front of it's painted and looks beautiful. Would you like to see it? Yeah, I think I got it. It might be in the one of those staff reports. Yes, sir. And my grill is removable as well. It's just all it is a straight up wall, a countertop, and a removable grill that I like, charcoal grill.
What's the height of that wall?
It's 6 feet.
6 feet, okay.
Yes, sir. It's 6 feet by 16 feet long.
Like the grill itself is all built out of like masonry, right?
No, the grill is cast iron. It's a removable grill that I bought. It's an Argentine style grill, and you can like pick it up and move it. And everything else is just masonry and concrete and cement, and rebar and all of that.
So if you can pick it up and move it, have you thought about just moving it up a little bit to get away from your neighbor's yard?
Well, the concrete can't be moved.
You ain't moving the concrete.
Yeah. Yes, sir. Basically I was just trying to show it's just like a concrete countertop with a grill that sits on it. And what was a hand
grill
sink.
that sits on, we really just mean it's the cast iron grill itself.
Yes.
Like you build the fire on what you built.
On the cast iron, yes, sir.
Okay, I got you. But it is on cast iron, not
Yes, sir.
straight on the. Okay, I saw one picture. I think it wasn't done yet.
Yeah, it's like a cast iron box.
Gotcha. Okay,
Yes,
that
sir.
makes sense.
And so that's it. And like I said, I've removed the water. There's no more drainage issue. There's no water going in or coming out. And everything else, I've already applied for permits on everything on this, and then I will do the gazebo as well if this passes.
Okay. All right. Any other questions, or did you want Mr. Waldrop to say anything? We have a little more time.
Yeah, sure. Thank you. Yes, my other neighbor.
All right. Stevens, you'll give your name and address for the record.
Yes, my name is Stephen Waldrop. I live at 2081 Linden Avenue.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, sir.
Thank you. I've been a resident at this for 11 years in the Idlewild Historic District. I'm here to support my neighbor's variance. It's been a positive addition to our neighborhood. Idlewild is a historic neighborhood. As you know, we put a lot of money into our homes, rebuilding them. It's a beautiful place. I think that this is a beautiful addition to the home. I watched it when it got built. I can see it from my deck. It does not, talking about the gazebo, it doesn't change anything. It's actually nice to look at. Along with the grill, it's adding value to the neighborhood. It's adding value to that property. I wanted to comment too on Linden Avenue is at a slope, so it starts at the top of the hill and it comes all the way down. This resident, no matter what we do, they're gonna have runoff in their backyard with the slope of the street. So no matter what happens, they're always gonna have runoff in their backyard from rain or anything else. I live on the top of the hill. All the rain goes down. It's just natural. So whether this variance is approved or not, they're still gonna have washout. They're gonna have stuff coming in their backyard every time it rains. There's nothing that's gonna stop that.
Okay. Any other questions from Mr. Waldrop?
Thank you.
Thanks. questions for anyone before we move to discuss? All right, if we could get a motion to approve BOA 2620 as conditioned by staff.
So moved.
Second.
Second. Any thoughts?
Well, we can start with the gazebo, I guess. And I do agree with that last point. You know, having that much concrete in your backyard for a pool, I mean, that's legal, that's fine. So I don't think the pavilion or the gazebo is the cause of runoff. You know, it's the fact that you have a lot of concrete decking in the backyard. So I don't think if that gazebo moved 3 feet or moved 2 feet, that's not going to change anything about runoff. So gazebo, I have no issue with. The grill, if the fence can go back up properly and they can come up, they can find a way to make the fence be the separating factor, I think everything's on the other side of it is hidden. And again, the height will be less than the grill. I mean, the height will be less than the fence. So I'm not even having heartburn on that one either, especially with the removal of the issues with plumbing. We just got to figure out how does that happen with where the fence is scheduled to go, and what the plans are for that.
We don't know that.
Yeah, that's what we don't know. How do you tie in a fence to the grill? I mean, I hope the intent is not to fence to the grill, stop it, and then pick it back up on the other side. You know, I hope there's a.
So could we condition this on the installation of a fence that abuts against the back of the grill or within so many inches of the grill?
Would that not mean he would have to do the fence, but this property is on this particular application, so. If we're conditioning.
We're kind of conditioning on them coming to an agreement.
Because of
and that's the hard part.
Sounds like.
I mean, I'm sure there's a way it can get figured out, but then to approve it and say y'all figure it out is a little funky, I think.
I think, I know he wasn't for a 30-day hold, but I think a 30-day hold would give them time to have that conversation.
That was my thought. We were thinking, because of the span and because of the issues with the foundation, could you not, do your foundations on just either side of the fence, and then if everybody was in agreement, could the wall actually be used as an attachment point for the fence?
Good question for somebody that's not us. You know?
Yeah.
Yeah, I think that.
But then again, does it not work because they are choosing to go with a taller, more robust fence? I mean, could a standard fence have worked?
Yeah, well, I mean, I guess but they're allowed by right to use that fence, and because of the structure they can't put in the fence, they can get by right. So the grill going where it's going, if it's messing with the fence somehow, that's a problem the grill's causing, I think. I think I'd be in favor of hold, and for them to discuss it and try to come up with a plan on how to work. And if they can't come up with a plan on how to work, present the plans they think on how it would work. So, and us, we've sometimes held stuff for people to try to make an agreement, and it didn't look like a good faith, the parties looked in good faith to do it. And I would say we'd want to see some sort of good faith effort. But I think that the grill being so close to the line is it's limiting what sounds like from the contractor, it's limiting what he can do by right with his yard. And a fence on the property line is a lot more normal than a wall and a grill. So that's why I think I'd be in favor of a hold to come up with a plan for the fence. It sounds like we've worked out the water and stuff like that, but I think being able to build the fence that they want, or just, I know people could say, well, you could just put a fence right up to the edge of it and we just use the wall as a fence. Well, maybe he doesn't want the wall as a fence.
No, I wouldn't do that.
You know?
No, I wouldn't do
So
that.
I think I'm with you on the gazebo, but I think we might as well just wait and vote on it all at once.
Is this, I'm sorry, was that?
Yeah.
I was gonna say, yeah, I mean, I think, I don't care if we hold or not. If the applicant is gung ho on saying, I wanna roll the dice on voting for it, do we vote for it? And if it votes down, I mean, he has, I guess whether we hold or not is contingent on if he feels like it's gonna be in good faith to make some type of.
I don't even know how to do a condition though on if we were to approve it, so long as they come up with a plan on the fence. Like I don't like. So I think what we'd be voting for is whether or not we just say, go ahead, you can have your grill. They can figure out the fence. So I don't think that's fair to the neighbor to approve it. Unless for somebody on the board just saying, yeah, we're never going to approve the grill. But I don't get that feeling. I think we can come up with a solution, or they could on this. That's why I think a hold and talking about it and trying to at least come up, maybe Poe Engineering that's going to give a letter can say, yeah, you can attach. It's not going to be a problem to attach the fence to it. That helps with the foundation.
I agree. I mean, a fence can be installed with that wall. I have no doubt. What I understood was the plumbing was the issue that prevented the fence from being installed. So now that the plumbing is removed, the fence should be able to go.
Well, no, they said the plumbing and the how they had to dig down, like the actual
Right, but you can dial into an existing footing.
I don't know. Like I'm not. You know more about that than I do.
Yeah, architecturally, I'm saying
it can be done.
It can be done like pretty easily.
Well, I agree with the idea of trying to get them to talk and work it out. It sounds like there are ways to work it out. Maybe they can come up with some agreement that everybody can live with. Because probably if we have to vote now, I mean I'd have to vote against it. I mean he is in violation of the applicable rules and it's affecting his neighbor. So if it wasn't affecting anybody, that's one thing, but it is affecting his neighbor. Might be in a bad place if we vote now, but if we give them a chance to work it out, to see if they can come up with some type of solution and come back, that might help get me to a place where I could vote yes.
All right, any other thoughts? Okay, would someone like to make a motion for a hold?
So moved.
Second.
All right, is there any, all those in favor of a hold signify by saying aye.
Aye.
Any noes? Hearing no, so we're going to hold this case